Hello, everybody.
Welcome. Thank you for joining us today for this webinar. My name is Dave Longo. I'm a partner here at Oblon in our electrical and mechanical practice groups, and I work primarily in prosecution and counseling. And my colleague Rob here.
I'm Rob Tarku. I'm also a partner in the electrical mechanical group. I focus a lot on electrical and software type inventions. I've also, prior to becoming an attorney, I was actually at the US Patent and Trademark Office as an examiner, examining in the image recognition, character recognition technology space. So thank you for joining us.
So we have a presentation today that's kind of tongue-in-cheek titled, "What the Heck is Going On in the US?" Normally, I think, as you know, patent law can be a bit boring, and maybe we have just a few updates each year. So it's a kind of a sleepy practice. But in the past year, we've had several changes per month. That a lot of goings on, policy changes, practice changes. So this presentation is going to give you an overview of some of those changes and the impact that might have on our daily practice. So this is the outline of the topics we're going to cover today. I will start with the first half of the slides that address the administrative policy, the backlog of unexamined applications, as well as the office's use of artificial intelligence to improve their examination processes. And then my colleague Rob will take over with the second half of the slides that address other changes that have been implemented under the new administration. I'll mention too, if you do have questions as we go, I believe you can type them into the chat. We'll try to have one of us keep an eye on them, and if we miss it during the slides, we'll come back to it at the end if there's time. So on the administrative changes in terms of leadership, the Patent Office leadership positions typically change with each new administration. These are political appointed positions. And so we had Coke Morgan Stewart sworn in as the acting director of the PTO back in January 2025. And then a month later, Howard Lutnick was sworn in as the Secretary of Commerce. Now, the USPTO is an executive agency underneath the Department of Commerce in the U.S. government, which is part of the executive branch. And so the chain is from basically the president to the Department of Commerce and then the USPTO. And then later last year in September, we had John Squires sworn in as the director of the USPTO. So just a bit of background on each of these three key players at the USPTO. Ms. Stewart has been at the office for about 10 years and has held several leadership roles there during this time. She does have a career background in IP litigation and has participated in 70 appeals at the federal circuit. She has, of course, her background in private practice, and upon the swearing in of John Squires, she returned to her role of as the Deputy Undersecretary of Commerce for IP and the Deputy Director at the USPTO. So she is still actively involved even now that John Squires is the Director. This is Howard Lutnick, the Secretary of Commerce. He has extensive direct experience with the U.S. patent system. He's a named inventor on over 400 U.S. patents and 800 worldwide patents. And he's not just, as some would say, an accidental inventor, but had a leading and active role in his companies, where he was the CEO of Cantor Fitzgerald, a financial services provider firm. And so he has extensive experience in the fintech field. Now, as far as patents and IP policy, he plays a central role in implementing the administration's tariff and trade agenda, which in turn can affect the intellectual property. And this is John Squires, the director of the PTO. He also comes to us with an extensive background in IP. He was the chief IP counsel for Goldman Sachs, and he was a partner at Dilworth Paxson. He too has experience in financial technology or fintech. Now, he does have and has been quoted in the media as having a very extensive, expansive view of Section 101 jurisprudence. So things that would be eligible for patent protection in the U.S. Think of the Alice and abstract idea type of cases. He gave public remarks at the AIPLA annual meeting, October 31st of last year. And he is also, as we learned from that speech, a big proponent of the use of AI in the office, for examiners, for the community in IP to improve patent examination. So the new administration comes in, they've made their appointees take these leadership positions at the office, and they have their own policy. They have their own themes. And so the messaging that we've been hearing is that the U.S. patent system, the patents themselves have been under attack, that the inter partes review practice is relentlessly killing patents, that patent eligible subject matter case law, so-called Section 101 case law, is out of control, and there's a huge backlog of unexamined applications at the office. And so also that the government does not receive any return on their investments in the patent system. And so what do they want to do about this? Well, they want to establish a more patent-friendly framework. They want to reduce the number of unexamined applications that are sitting in the backlog. And they want to do this in part by increasing and integrating the use of AI into the office. So here's a look at the total inventory of patent applications sitting. We're over 1.258 million now. And this is the unexamined inventory of applications sitting, waiting for first office action on the merits. And you can see that that number has increased over the last several fiscal years and then tapered off in fiscal year 2025.
And just as an aside with regard to reducing the backlog, this has always been an issue for the Patent Office, and every administration has had its own take on how to do that throughout time. So this has always been a very hot topic that basically every administration has taken on at one point or another.
So I mentioned the patent-friendly framework. And as you may have experienced in your companies or with your clients, that the Section 101 or patent eligible subject matter area has been extraordinarily difficult to get through the office in recent years. And so we had a recent appeal at the Patent Trial and Appeal Board, this ex parte Desjardins case, and it involved AI via a machine learning model. And the board introduced a Section 101 rejection and said the claims that were at issue were not eligible for patent protection, putting aside the patentability rejections under 103 for obviousness. Well, Director Squires, then newly sworn in, intervened in this case and overturned the board and said that they had analyzed the claims too broadly, that they had emphasized the negative effects of excluding AI innovations, and returned the case for evaluation, further evaluation under Section 102 for novelty, 103 for obviousness, and Section 112 for written description and enablement. And this case, I think, interestingly reinforced that the traditional novelty and non-obviousness ways of evaluating the patentability of claims should be preferred. And a few months after this decision came out, it was designated as precedential, which means it is binding on future PTAB, Patent Trial and Appeal Board panels. Now, following this decision, the office issued a memorandum, a guidance, basically on subject matter eligibility declarations, or SMEDs. And this reminded the applicants and practitioners that such declarations can be useful to help address or overcome Section 101 rejections in this space. So in December, the office issued guidance and a memorandum to the patent examiners. And this basically reminded everybody that you can submit a declaration, like a 1.132 declaration, to introduce factual evidence that's germane to the eligibility inquiry. Maybe something that shows technological improvement or how the invention is integrated into a practical application. And the memorandum to examiners emphasized that if an applicant submits such a declaration, that the examiner must consider it as part of the evidentiary record and evaluate it accordingly. So basically, this is encouraging us to use one of these existing tools that's already there in the office for us to avail ourselves of to help overcome such rejections when we encounter them. Now, this also addressed an issue where they came out and said, we're going to update the MPEP, the Manual of Patent Examining Procedure, to give a heads up that there's going to be some changes on the sections in Chapter 2100 addressing Section 101 subject matter eligibility. And so this is going to emphasize that the examiners should look at the specification of the application for disclosure of an improvement to computer functionality or to another technical field, something that allows them to determine whether the claim itself reflects that disclosed improvement, and to remind examiners to avoid relying on bare or empty conclusory assertions of improvements without any technical detail. So the examiner should not dismiss additional claim elements as being generic or generic computer components without first considering whether they offer some improvement to a technical problem, such as an improvement to a computer component or to the computer system itself. And so now we're in this period several months later where we are starting to see some movement on Section 101 in terms of fewer rejections and use of these additional tools to help us overcome them.
What's very interesting about the memo to me is when I first read it, it didn't seem like it said anything new. It was basically reiterating things that we already knew for years. But I think the importance of it is really the training that the examiners received from it internally. We've spoken to many examiners. We have many contacts at the PTO, and they all said that basically they were encouraged to make less one-on-one rejections. Make a one-on-one rejection, not if you're unsure, but if you're really sure that one should be made. And as a result of that, we have seen, I personally have seen at least, changes in the way examiners approach one-on-one. And maybe cases that I was expecting a one-on-one rejection in previously, I no longer receive one, or it's a little more easier to overcome. So I think the memo has really, really helped push the one-on-one rejections along and helped cases move forward that perhaps before were kind of stopped. We're at a dead point.
And I mentioned earlier this patent-friendly framework that the USPTO is pushing now. And one area where this is starting to take shape that we're seeing involves, again, the use of AI. And so in late November last year, the office rescinded the document inventorship guidance for AI-assisted inventions. Now, a previous memo on this topic had recognized human inventorship while introducing AI-specific analysis. And that could create extra complexity in determining inventorship if AI is involved. Well, this 2025 revised guidance reverts to one standard for all inventions that focuses on traditional human conception only. So basically, this removes that AI-specific inventorship framework and treats AI purely as a tool with no special criteria for inventorship. And I think this is important because this is going to tie into the way that the USPTO is implementing AI as a tool within the agency. Okay, addressing the backlog of unexamined applications. As my colleague Rob mentioned, this has been an age-old problem. Every new administration and every new director comes in and says, what are we going to do about the backlog? We have too many unexamined applications. And so, as we probably could have predicted, the new director, Squires, said he would prioritize reducing the backlog of unexamined application. And to do that, in his public remarks, he said repeatedly that he believes the office should lean in to the use of AI to provide tools to reduce that backlog and do so in a way that aids examiners, helps them to be more efficient. Now, since January of 2025, we have observed a decrease in the number of unexamined applications. There was a high of about almost 838,000 in January, and by December, that number had gone down to about 795,000. And so here's some data from the USPTO's publicly available dashboard that shows that, in fact, that backlog has been going down. The trend is now clearly decreasing. Now, initially, in the earlier part of the year, we might have been able to attribute that to the increased fees, the increased government fees for filing, say, continuations after 6 years or 9 years, the increased fees for RCEs. But subsequently, the latter part of 2025 and now into the first quarter of 2026, we're still seeing that steady drop. Yes, there was a slight uptick at the end of the year, but almost a blip when you look at the overall trend of this graph. So, in fact, just last month on April 10th, the USPTO announced that they had, quote, turned the corner on this backlog reduction. And they were promoting the fact that for the first time in almost 10 years, the number of first office actions within a fiscal year is exceeding the number of new applications that are being filed within that year. And then they were touting as well that steady drop in unexamined applications. And the expectation is that will continue to drop. We're seeing no signs on our side, at least at this time, that shows any uptick in that number of unexamined applications.
And the reason that the USPTO expects the cases to continue to drop is that typically the latter part of the year, the last 2 quarters, are the most productive in terms of examining applications. So they think it'll probably continue dropping maybe at a higher rate than it currently is, because that's when examiners usually try to crank their cases out before the very end of the year and their evaluations are due. So we will monitor it. We'll continue to see. I am personally curious to see if this will indeed continue.
I've mentioned several times already the use of artificial intelligence. And so within the office, just mentioned several initiatives that the office is undertaking in terms of the use of AI. Now, January of 2025, the office released a memo, comprehensive artificial intelligence strategy to outline goals for AI adoption. And the office is internally developing their own AI tools. So this is not just a matter of allowing examiners to use ChatGPT or Claude or whatnot, but they're actually working on their own internal systems to leverage and better use the data that they already have. So some of these tools that they're developing are listed here on this slide. We have the first one called the MLTD, or the More Like This document, which is used to supplement examiner searches. They're also using this on the administrative side prior to substantive examination for document code quality control to help automate the onboarding and processing of newly filed documents in their patent center system. They also have worked on developing something they call Scout, a searching, consolidating, outlining, and understanding tool. This is designed to automate some coding to detect improper filings, to enhance cybersecurity, and so on. That's an internal generative AI tool and chatbot for use within the office. They're also working on a design vision, an AI-based image search tool to help examiners who are searching prior art for design applications. So again, I think this is promising, this is encouraging that the office is not just adopting something publicly available and trying to fit the square peg in the round hole, but instead they're actively working on their own systems, using their own data and developing their own models. Another pilot program that was announced in October of last year is called ASAP, or the Artificial Intelligence Search Automated Pilot. And this pilot program is designed to leverage AI for an initial prior art search of an application's claims. And so under this pilot, the office will conduct an automated search using their internal AI tools, and they would provide the applicant with what's called an Automated Search Results Notice, or ASRN. And this basically gives the applicant a so-called top 10 list of prior art documents in descending order of relevance. And under the pilot, then, the applicant can decide whether or not to file a preliminary amendment. Maybe some of the prior art looks like it could be close to the claims, and the office says, as part of this pilot, you can amend now to hopefully streamline subsequent prosecution. Now, the examiners are instructed to consider these documents in the same way as other documents that they would search on their own. And the documents that are part of this top 10 list in the ASRN would not appear on the face of the patent as a result of the examiner's search or the applicant's IDS submissions unless they are separately cited by the examiner or by the applicant in an IDS. Now, the goal of this pilot is to evaluate the impact of sharing this top 10 list of documents before formal or substantive examination begins. Now, to be eligible for this pilot, it's only original, non-continuation, regular, non-provisional applications. So if you have U.S. national phase applications, they are not eligible for this pilot, and not in continuations, divisionals, designs, plant, or reissue patents. Now, I previously advocated caution. I did not want our clients to be the sort of test subjects or the beta testers for this new program, because it wasn't really clear what constraints were being placed on the AI model that was doing this search and what types of references would be pulled, and would that model hallucinate or propose something that really was not a valid or important reference. And so now, several months later, we do have some data, and we also have an announcement from the office that extends this pilot program. So originally it was due to expire after 6 months. So that was on April 20th of this year, and it was limited to 1,600 applications. Now that program has been extended to June 1st, 2026, and the total number of applications that would be allowed in the pilot to double to 3,200. But when you look at the statistics, it's very telling. As of April 16th, there were only 169 petitions filed to participate in this pilot, and of those, only 76 had actually been granted, or meaning accepted into the pilot. And so the graph here on this slide shows you a breakdown of the number of those granted petitions that are filed as a function of the technology centers within the office. And so you can see, for example, the 2,800 for materials or semiconductors had about 12, whereas 1,700, which you think of for materials and chemical technologies, only had 2. So there's some variation here across the technology centers, and overall, a very low, adoption rate within the practitioner community. I mean, we're still only at about 10% of the original total of eligible applications. So we're going to continue to watch this and see if the data changes much in terms of the acceptance of this program for the public and where it may go. And with that, turn it over to Ron.
Yeah, and one more thing that I wanted to actually say about this program is I believe there was a fee originally, and I forget what the fee was.
There's a moderate fee.
Moderate fee, but now they removed that fee. It's not on the slide, but I believe they removed it, so now it's technically free to participate. Also, unfortunately, when we were researching this, didn't really see any data on why only 76 were granted. So we don't know what the others were denied based on. We're not really, to be honest with you, sure. And that's exactly a question that we currently have. Why have it been rejected? We don't know. There's no, it could be for various reasons. I mean, it could be, for example, if you're a national phase, so if you didn't really fall with or follow the proper procedure of a new non-continuing U.S. application, that could be one. But other than that, I'm assuming that you are within that framework. I'm not really sure why it would be denied, especially given that there's such a low number of petitions that have been filed. So my own gut instinct is that this program will probably go away or will change dramatically in some manner if they decide to continue it. There was also another question here that I wanted to address kind of before we go on to the next section. So yes, RCEs do not trigger the new unexamined application. That's not an unexamined application. It's starting the cycle again. So that does not fall into the unexamined data. Many of you may remember this, but maybe about 10 or 12 years ago, the administration at the time tried to, again, also reduce the backlog of unexamined applications. And what they did is they incentivized the examiners to pick up new applications by giving them extra credit for that, extra counts. And I forget the exact how they actually structured it. But then for RCEs, a little bit less of a count. So what ended up happening is the backlog dropped. There were more unexamined applications being examined. However, the wait after you file an RCE to get a first action became very, very delayed. So we had some cases, I remember it took basically about a year from RCE filing to get another action. So it basically shifted the ball to another side of the fence.
And, in this sense, to that point that, yes, the RCE does not count for the unexamined application, but if you think about it, the amount of time that examiners are spending looking at cases with RCEs, like Rob said, then that limits and reduces the time available for them to examine new applications. And so when the office dramatically increased the fees for filing second and subsequent RCEs. Again, they're trying to disincentivize the filing of RCEs. So if there's less RCEs filed, then the hope is that frees up the examiners to look at more of the unexamined cases in the backlog.
Okay, so shifting topics to basically other USPTO changes on this new administration, we're going to touch on staffing, examiner interviews, and really their performance requirements and how they've changed, as well as a few other changes. Like Dave mentioned, there have been so many changes since the beginning of last year that it's almost impossible to kind of narrow them down to only a few slides. So here is a timeline of with regard to USPTO staffing, and we have sort of more detailed slides on each of these points later on, but I just wanted to kind of give a brief overview. So January 20th of last year, 2025, there was that return to office mandate that covered all of the federal government, not just the USPTO. And then on the 28th, there was a memo to defer the resignation program. On the 14th of April, telework was canceled for the probationary patent examiners, and as a result, 11% of them quit. As I'm sure you know, a lot of examiners, the USPTO has had a telework hoteling program probably longer than any other agency. I believe it started about 21 years ago, 2005. So many of these examiners have been working from home for a very long time, even way before the pandemic. So after 10 or 15 years of working from home, it is kind of challenging to require you to go back to the office. Now, this cancellation of the telework program, I do want to mention and underscore that it is for the probationary patent examiners, so it's not for the seasoned patent examiners. Probationary patent examiners are usually 2 years and under of being an examiner at the PTO. A few months later, on August of 2025, the examiners were stripped of their union, their right to organize and bargain collectively. And this caused a lot of uproar, and as a result, the union, as well as other federal unions, filed suit against the government.
Can I just add here too? I mean, the reasoning for this was trying to allow the government to have more control over the federal employees. I mean, the Patent Office union, POPA itself, is considered a strong union with representation of the examiners, and really very instrumental in getting this hoteling or telework policy and permissions up and running. And so the administration, I think, felt that their hands were a bit tied and that they did not have the ability to force the U.S. examiners back into the office. And so they're trying to probe different ways that they could make these adjustments. And so the thought behind this, stripping them of their collective bargaining agreement, was one way that they could undermine the union and then either fire examiners and replace them with new examiners not subject to the union, or do something else to overall encourage them to be brought back in to in-person work.
That's right. That's exactly correct. And so then in October, there was a reduction in force that the USPTO started as a result of the government shutdown. At the end of that month, the director announced that they would like to hire 1,100 new examiners. And then shortly after that, in November, the reduction in force was rescinded. So a lot of different things, maybe things that even appear to be contrary, have been taking place. Now, this we've sort of covered already. I do want to mention something before I forget. So the PTO has instructed people, their employees, to come back to work. As Dave mentioned, the examiners are covered, or were covered, I should say, by a union. So because of that, it made getting examiners back to the office very difficult and challenging for the administration. However, not everyone that works at the PTO is covered by the union. The union typically covers only examiners, both on the trademark and the patent side. Supervisors like SPEs, judges at the board, petitions folks, all of those people are not covered by this union. So therefore, they were actually forced to come back into the PTO. I believe the last number I heard was maybe 2,500 total employees are back, which is a big number. However, in the scheme of things, the PTO is about 14,500 employees, so it's not really that big of a number if you think about it in the scheme of things. Just sort of for more background with regard to the Getting Back to Work program. So basically, if you live within a 50-mile radius of the PTO, then you are required to come back in. Again, for non-examiners, for folks that are not covered under the union. If you are beyond that, but also not covered by the union, so maybe if you work in petitions and your colleagues live farther away than you do, well, originally they were going to have them go to a local federal building, so maybe a post office, for example. They went back and forth on that. It wasn't very feasible. They also would have to pay rent to that government organization for the space. So although that was one of the thoughts that was going to happen, that basically went away. So it seems, and I've talked to some folks at the patent office, but it seems in a way that folks that live within the area of the PTO are in a way being punished to go back. Whereas if you do the exact same, you work in the exact same department and you live outside that area, then you do not have to come back in. So it's just very interesting the way that has been handled. And of course, things always change, so we'll see how things go. Okay, so we mentioned earlier, I think Dave mentioned earlier about the push to remove the union from representing the examiners, and they used, there's a memo that came out, and the executive order, I should say, actually, that said that, well, examiners deal with national security work. So because they deal in such type of sensitive work, they do not have the right to be overlooked, to be handled by a union, to be covered by a union. As a result of that, this is where the lawsuit comes in, where the union stepped up and are fighting in court currently.
But as we note here on the bottom of the slide, because they realize there's limitations in the physical space available, as Rob mentioned, even while this change is going on, and there's the fight between the administration and the union, they're not changing the telework policy effectively because they don't have the space to house these examiners. Here at the USPTO campus in Alexandria, there were 4 buildings plus the main building, and the office gave up the lease in 2 of the 4 buildings. So they can no longer bring everyone back even if they wanted to, at least not here in Alexandria.
So as we mentioned earlier, the labor unions, so POPA, that is the PTO one, they sued, as well as other labor unions, such as the National Weather Services, challenging the validity of this executive order. Currently, it's been stayed right now. So it's on pause for now until other litigations reach some sort of conclusion. So right now, the examiners are still technically covered by the union. So there's no change in that regard. The other thing that I wanted to mention with regard to this, sort of as a plan B, I mentioned that Director Squires is looking to hire 1,100 new examiners. And what we understand from talking with folks at the PTO is that these examiners, they would like to hire them so that they're not covered by the umbrella of the union. So almost like as a plan B, if the unions end up winning in court, they want to have an examination corps that is not covered by the union, and perhaps they can require them to come into the office, for example. And one way to do this is really, from my understanding, is really they're trying to change the job description a bit about about patent examiners. So perhaps maybe have some extra tasks that the examiner has to do, just so that the examiners, as new hirees, will not be covered under the union. As far as we know, we've not heard of these new examiners starting yet, so I don't know where the process is yet. Maybe they're being interviewed currently, but that's sort of the rumor going around at the USPTO. We basically covered most of this.
Yeah, this is really addressing the tug and pull, the yin and yang, the pushback, and the just constant changes to, are we hiring examiners? Are we firing examiners? And are we hiring examiners that we can keep out of eligibility to participate in the union? And so this, this was going on all throughout the government shutdown last fall. Now, they're talking about hiring new examiners. But again, I think the message is these new examiners would not be able to participate in the union.
Exactly.
So I think even if the lawsuit is successful, they're already trying to take steps to circumvent that union.
Exactly. So further on the reduction in force, so in October of 2025, the USPTO announced that it's closing one of its regional offices. That was the one that's in Denver, Colorado. They didn't really go into details as to why, but effective teleworking policies made physical office space less necessary was really the reason for closing it down. So we're not 100% sure, to be honest with you, what that actually means. While this is happening, in December, they announced that they are trying to open a new Montana office as a community engagement office to serve the inventors in a particular region of the country. So while closing one office down, they are opening other offices, but again, more for community outreach than for an actual examination type of office. In February, so just 2 months ago, they announced that the USPTO is also opening another one of these offices in Utah as well. And I believe that one's actually been opened, I think late February that actually opened. So 2 new offices, these regional, these community engagement offices have been opened. So a little bit more on staffing. This chart shows that the appeals at the PTAB over the years, I guess a 14-year period since 2012, has dramatically been reduced. This 26,000 to about 2,000 this fiscal year. So it's been dramatically reduced. As a result, and also as a result of the IPR proceedings and the director's aggressive use of institutional denials, there's less of a workload for the PTAB judges. So historically, about 230 APJs and then maybe another 120 support staff have occupied the space. Though now in recent years it's closer to 200, especially after the DOGE retirement initiatives. So basically the decline in cases suggests that the PTAB might currently actually be overstaffed. So we think that soon we will see, I think, a reduction in force there as well, whether judges leave voluntarily or are forced for early retirement. So we'll continue to monitor that as time progresses. But it's quite a big decline in the number of cases that go to the board. So switching topics yet again, everyone's favorite topic, examiner interviews. Amidst this push to get cases picked up quicker, allowed quicker, increase quality, and move things forward as the current administration is trying to achieve, surprisingly to me, they actually reduced the amount of interviews that an examiner gets credit for. So typically before, as long as the examiner agreed to have an interview with you, they would get a particular type of credit, they're called other time. So I think they usually get about an hour and a half of other time, non-examining time, to prepare and conduct the interview. Well, now that's been limited to basically only one time per prosecution cycle. So the examiners are able to do another interview, or as many interviews as they want, they just do not receive credit for it. So as you can imagine, many examiners have expressed frustration with this change and with many other changes which we'll go through. And of course, from the practitioner's point of view, this may be a challenge to get interviews because different examiners handle it differently. I spoke to an examiner yesterday, and he out of the blue told me how he loves interviews. He thinks they're very useful, and it helps him move the case along quicker and understand it and do a quicker examination as well. So he actually, out of his own time, he prefers to take that time to devote to the case, to learn about the case, because he thinks that this actually does help him get the case through quicker. Now, there's other examiners who, of course, if you don't provide credit for me, I will not do that interview. So there are examiners that refuse to do the interviews. But it's basically, at this point, it's up to the examiners. Some examiners, maybe more the junior examiners, have to get permission from their supervisors. So there's sometimes you will call to arrange an interview, and they will say, well, I don't know if my supervisor will allow it. Let me check. Let me get back to you. So just more back and forth between calling and trying to set up an interview and actually having the interview, if at all.
I'll add too, in practice, for a practice tip, if you will, we're generally encouraging to conduct interviews earlier in the process. In the past, it would be fairly routine to get a discretionary interview even after a final office action. Sometimes, it did get that far before you really had to get a substantive discussion in with the examiner. And now that's much less common. After final, we've had, in our experience, examiners just deny the interview for the reasons that Rob mentioned. So instead, we're pushing to interview cases earlier and keep in mind that it is that one interview per cycle. So again, we realize the examiners are in a tough, difficult position here. So we don't want to aggravate them or burden them more than we have to, because that could affect their sort of subconscious disposition towards the application. So just think strategically for your clients, for your applications, and keep in mind that timing is critical for that one interview, so you can make the most of it.
So the performance requirements for examiners, so how they're evaluated at the end of the year, has also changed quite dramatically. And as you may imagine, examiners typically are not really prone to change. They don't really like change very much, as I guess most people do not. But I feel specifically examiners, people that join the PTO join it because there's a sort of foundational the way things are done. And it's expected. People know what to expect. And then in the last year, it's been more of a shock for them, and it feels that this is just from talking to examiners. It feels like every day is something new or something changes. But with regard to their performance, so the goal for this year, fiscal year 2026, is quote unquote excellence and accountability. There's heightened production requirement for most senior examiners. In fact, there are SPEs, supervisors, typically never, they don't have their own docket. They don't actually examine cases. They review examiners, they train. But for those tough cases that basically there's no end in sight, they do shift them to the supervisors to examine them. So again, this is folks that have been supervised for 20, 30 years, but not examined in so long, and now they have to examine certain cases. and do so in the office. So it's a double whammy for them. So as you can imagine, a lot of upset examiners. The production goal has also been increased. It weighs more now towards how fully successful you can be at the end of the year. Also, they've changed. So previously, as long as you did your work and as long as you hit certain categories, which we'll see on the next page, on the next slide, you would be fully successful. So you can have an entire art unit where every examiner is fully successful because they each met their requirements. Well, now they've making it a little bit harder. Basically, they will only issue maybe one or two, so just a small handful of fully successful. Everybody else cannot be fully successful. So as you can imagine, there's also, I feel, creating maybe a tension or maybe a competition between the examiners themselves within a group, within an art unit, that was just not there before. So again, more reasons for them to be frustrated. In fact, I had one examiner just last week tell me that he feels like he's in corporate land, because this is typically the way it is in corporate, especially corporate America. So he was quite disappointed with regard to that. And also the last point on this slide is SPEs now. So they always had to review office actions from junior examiners. Usually it was 2 per quarter. Now it's been increased to 4. So just basically more review for the junior examiners for their supervisor. Here's a kind of a quick chart about how things have shifted. So again, higher production counts for more, basically. Quality counts for more. How that's measured, that's always been a tough one to measure in terms of quality. And of course, docket management stayed the same, and then professional interaction stayed the same. The other thing that has changed, is not really on this slide, but another thing that has changed is they require now to meet certain bonuses for examiners. So a lot of examiners produce over their production requirement, so they can hit certain bonuses. Well, now they've basically kept the bonuses in terms of dollar amounts the same, but they require more cases. They require basically more work. I think it might be double per tier of bonus. So as you can imagine now, if you have to do 10 cases more, now you have to do 20 cases. So this is also another frustrating aspect for them, because a lot of examiners, especially the more senior examiners, do try to hit these bonuses for extra income. So it's financially affecting them in ways as well as just the day-to-day. Just very quickly on this, with regard to the PPH program, late last year in October, the USPTO simply changed the docketing of PPH applications. The idea here was to slow things down. So not speed up, but slow things down. Basically, the PPH cases were being picked up too quickly, and applicants were receiving office actions too quickly in comparison to non-PPH applicants. And the administration thought that this was unfair to the other applicants. So now they just changed the docketing a little bit, so it takes a little bit longer to receive that first action. And also in January of this year, the PTO announced its extension of the IP5 PPH pilot program. This will be extended for another 3 years to January 5th, 2029. IPRs, we mentioned this earlier, they're the killing machines. This is a chart showing how IPRs, the institution rates have gone down considerably, especially towards the very end of the year, last year. This is basically due to the sort of strong position that Squires has taken against IPRs. So there have been a lot of denials. We noticed that at sort of the beginning of this year, there's a bit of an uptick, still lower than what it used to be, but a bit of an uptick in institution rates. And we think that might be maybe to applicants strategizing more, realizing more maybe what Squires and the PTO are looking for, so adjusting their IPR accordingly. But this is all an entire topic onto itself. What's very interesting, and I wanted to show this graph, is as the denial for IPRs skyrocketed, which is the blue line there, as you can see, went up, the ex parte reexamination requests also went up. So showing basically that applicants are strategizing and they're saying, okay, what's the other thing we could do? What's the next best thing that's at our disposal? Ex parte re-exams have had quite an uptick, 60% uptick since the IPR denials and the IPR rates have been going down. And finally, just two other things that we just wanted to mention. There's many pilot programs and many programs that the administration has come up with. One of them is this Spark pilot program. This is intended to incentivize small and medium-sized businesses, universities, or nonprofits to participate in the standard development organizations. And basically what it does is it offers a limited number of what they call acceleration certificates to U.S. entities. So it has to be eligible U.S. entities only that make technical contributions to participate in SDO activities. And this is, again, to encourage. They realize that small and medium-sized businesses do not have the funds to partake in these developmental organizations, and so they want to encourage that by helping them get their patent faster, basically. So that is a pilot program that has started. The other one, which just got approved, it was I think in October, it was proposed and now it's been approved recently. It's requiring foreign domiciled patent applicants and patent owners to be represented by U.S. practitioners before the PTO. This was been the case on the trademark side for quite a while, but not on the PTO side. So now, basically, you would need a U.S. patent practitioner to represent you, to represent a foreign company or foreign individual before the PTO. And with that is the end of our presentation. There are a lot of topics. We touched upon them. I mean, some of them, there's a lot more details, like the IPR is a lot more details. Again, that's in a presentation onto its own. But we just wanted to highlight all the things that have been happening because, as Dave said at the beginning of the presentation, usually during an administration, there's maybe an update a month or every few months. I feel now it's almost weekly. Weekly, if at the very least, monthly. So a lot of changes. It's hard to keep up with all of them, but we try to paint a picture kind of from the beginning of the administration to now to kind of see how things are going and how things are flowing at the PTO. So we hope it was helpful. And of course, if you have any questions, please feel free to put them in the chat box and we'll try to respond as best as we can.
Yeah, or if you think of something afterwards, please feel free to reach out to email us or any of our colleagues, and we'd be happy to get back to you.
Absolutely. If it's an easy question, feel free to email me. If it's a hard question, feel free to email Dave, please.
Thanks for hanging in there with us. We really appreciate you taking time out of your day. Yeah, thanks again, everyone.
Thank you.